Mr. Wortzman was educated at the University of Toronto, graduating in 1967 with honors, admitted to the Bar of Ontario in 1969, gaining on the way the Law Society's second prize and the Lawyers Club second prize. Barry has practiced exclusively since his graduation in the field of civil litigation before all levels of courts, including the Supreme Court of Canada, with particular emphasis on corporate civil and professional liability claims, which is the subject matter of today's paper. Barry continues to be a member of the firm of Shibley, Wrighton, and McCutcheon, and has appeared as special counsel to several government committees, one of which I must mention because it bears directly on the paper today. Barry served as special counsel to the Professional Liability Insurance Committee of the Canadian Institute of Chartered Accountants. Barry continues to contribute to the bar admission course here in civil litigation and is on call and lectures from time to time at the Faculty of Law in the University of Toronto. I'm very pleased to have him here this morning, and Barry Wortzman.
Within my topic, I propose to examine a limited number of current issues, which I hope will be not only of interest, but which may give some tentative insights into the approach which our courts appear to be taking on some what I consider to be important and relevant questions, namely informed consent, novus actus interveniens, and the corollary question to it, contribution and indemnity, among tortfeasors under the Negligence Act. In 1980, the Supreme Court of Canada delivered 2 judgments respecting the duty of a doctor to disclose to his patient the risks of a proposed treatment. These 2 decisions, Hopp and Lepp and Ribel and Hughes, have prompted much discussion and debate. After briefly setting out the issues pre-Hopp and Ribel, as well as their recent resolution, I propose to focus on the manner in which Hopp and Ribel have been interpreted and applied by lower courts. Interestingly, it will be seen that while Hopp and Ribel have changed or at least clarified the law, they have not to date changed the outcome of most doctor-patient litigation. Before Hopp and Ribel, doctor-patient litigation involving a question of informed consent was the subject of considerable confusion and unpredictability. 3 issues repeatedly surfaced. 1, does the patient plaintiff's claim that certain risks of treatment were not disclosed sound in negligence or in battery? 2, what is the appropriate standard or scope of disclosure necessary to avoid liability in negligence? And 3, by what standard must the patient prove that he would not have undergone the treatment had he been informed of the attendant risks traditionally referred to as the issue of causation? Before Hopp and Ribel, inadequate disclosure cases were pleaded in battery or in negligence and battery in an attempt to achieve various procedural and substantive advantages. For example, in respect of a battery claim, the plaintiff was only required to prove a prima facie case that the defendant had intentionally made physical contact or performed the operative procedure without his consent, whereupon the onus then shifted to the defendant doctor to prove that there was an informed consent. Similarly, uncertainty existed as to the appropriate standard of disclosure. While most Canadian courts opted for the so-called professional medical standard, which succinctly defined meant what the reasonable physician of that specialty would tell the patient in the same circumstances, they did so in the face of American decisions in favor of the more patient-oriented full disclosure standard, which again can be succinctly referred to as what the reasonable patient would want to know under the circumstances. Finally, pre-Hopp and Ribel, the issue of causation was problematic. Canadian courts initially approached the question by focusing on the particular patient and formulating a subjective standard of causation. They asked, would this patient have given his consent to treatment if he had been adequately apprised of the risks? Subsequently, 2 lower courts expressed discomfort with a theory of causation that permitted a patient to color his testimony with hindsight and bitterness, thereby placing the trier of fact in the position of deciding whether a speculative answer to a hypothetical question is to be credited. Read together, Hopp and Ribel resolved these 3 informed consent issues and formulated a new duty of disclosure. I think it's important when we start to get into an analysis of the cases post-Hopp and Ribel to understand what the factual context was that the courts were dealing with in those 2 cases. And I'm going to briefly set out the facts, if I may. In Hopp, the plaintiff suffering from a slipped disc was referred to the defendant orthopedic surgeon who was practicing in Lethbridge, Alberta, who performed a myelogram and determined that surgery was necessary. The operation was unsuccessful, and the plaintiff was referred to a Calgary neurologist who in turn referred the plaintiff to a Calgary neurosurgeon. The neurosurgeon performed a second operation which worsened the plaintiff's condition. While the trial judge found that the original operation had been performed competently by the defendant and that the defendant had adequately disclosed the attendant risks, the majority of the Alberta Court of Appeal held, reversing the trial judge, that the defendant's risk disclosure had been negligent. In Ribel, the plaintiff, who was 44 years old, presented with complaints of severe headaches. The defendant neurosurgeon advised him that he had a major blockage in the left carotid artery that was reducing blood flow to the brain, a condition which made him vulnerable to a stroke or death. The plaintiff was of the erroneous understanding that the surgery to remove the blockage would eliminate his complaints. The defendant doctor failed to inform the plaintiff of the risks of stroke or paralysis attendant upon the surgery. During or immediately following the surgery, the plaintiff suffered a massive stroke, leaving him permanently paralyzed on the right side of his body and impotent. Ribel made it clear that the cause of action is usually to be characterized as one in negligence and not in battery. As Chief Justice Laskin explained, and I quote, "Actions in battery in respect of surgery or other medical treatment should be confined to cases where surgery or treatment has been performed or given to which there is no consent at all, or where, emergency situations aside, surgery or treatment has been performed or given beyond that to which there was consent." That much was clear. When dealing with the standard of disclosure, again, the duty is characterized as a duty to make disclosure of material risks, including special or unusual risks. When one reads the judgments carefully, it appears, at least to me, that what the court is there saying is that materiality can be a function of the gravity of the consequence, i.e., even if the consequence is only a mere possibility, if it is grave, it can be material. And in these respects, Chief Justice Laskin, referring to his earlier judgment in Hopp and Lepp, stated, "In obtaining the consent of a patient for the performance upon him of a surgical operation, a surgeon generally should answer any specific questions posed by the patient as to the risks involved and should, without being questioned, disclose to him the nature of the proposed operation, its gravity," and he goes on. The court in Hopp and Lepp also pointed out that even if a certain risk is a mere possibility, which ordinarily need not be disclosed, yet if its occurrence carries serious consequences, as for example paralysis or even death, it should be regarded as a material risk requiring disclosure. In dealing with the scope of the duty, Chief Justice Laskin rejected the professional disclosure standard and held that medical evidence is not per se dispositive of the questions what risks are to be considered material and what risks require disclosure. On the issue of causation, he was persuaded that objective criteria be given paramountcy. While not disregarding the relevance of the plaintiff's subjective testimony, the starting point is the reasonably prudent patient in the plaintiff's position. In this respect, he stated, the objective standard would have to be geared to what the average prudent person would agree to or not agree to if all material and special risks of going ahead with the surgery or foregoing it were made known to him. After Hoppenreibel, the common belief held by many was that the rejection of the professional standard in favor of full disclosure, factoring in the circumstances relating to the particular patient, would result in a tipping of the scales in favor of the patient. This does not appear to have occurred. Rather, in interpreting and applying Reibel and Hopp, the courts have carefully balanced the full disclosure standard against the objective standard of causation. In the result, in the majority of cases, the doctor is absolved of liability, even if his disclosure is inadequate. Characteristic of this approach is the Alberta Court of Appeal decision in the case of Zimmer versus Ringrose. In that case, the plaintiff advised the defendant doctor that she wished to be sterilized following the birth of her second child. The defendant advised the plaintiff of the various methods of sterilization available, as well as a new technique which utilized silver nitrate paste as a means of blocking the passages of the fallopian tubes. He further explained that a silver nitrate sterilization could be performed in an office setting and did not require hospitalization. The plaintiff selected the silver nitrate treatment primarily because it did not require a stay in the hospital. The sterilization treatment was performed, and the plaintiff subsequently became pregnant. Because exposure to X-ray radiation posed danger to the fetus, the plaintiff had an abortion. She suffered pain during the abortion, as well as considerable postoperative anxiety and distress. The court held that the defendant's disclosure had been negligent. In this respect, it stated, there was no comparison given by the defendant between his method and others. The plaintiff had no opportunity to measure the risks involved against those in other forms of sterilization. The defendant failed to apprise the plaintiff of the fact that the silver nitrate technique had not been approved by the medical profession. A reasonable practitioner would have made this disclosure, end quote. Nevertheless, the court also emphasized that although the defendant had breached the duty of disclosure, he could not be held liable unless a causal connection between his negligence and the injury suffered could be proven. This, the court held, the plaintiff had failed to do, since the plaintiff wished to avoid going to the hospital, and since all alternative methods of sterilization required hospitalization, even full disclosure, quote, would not have induced a reasonable person in the plaintiff's particular position to forego the silver nitrate procedure, end quote. In this case, and perhaps ironically, a subjective factor, the plaintiff's desire to avoid hospitalization, was combined with the objective test, the reasonable patient, to eliminate any liability. At first blush, it might have been believed that the principal thrust of Hopp and Reibel was to establish patient awareness of risks as the seminal or principal issue. This has not been so, at least in those cases where the causation issue, premised principally on objective criteria, has been seen by the court to involve potentially life-threatening situations in the event the procedure in question is not undertaken. Perhaps the most dramatic example of this situation is a recent case which came out on February 1st, 1983, and which is a decision of Mr. Justice Krever, whom you will be hearing later today. It's the case of William Ferguson and Hamilton Civic Hospitals. In that case, a 58-year-old male individual was admitted to hospital for testing after 3 episodes of temporary blindness. Upon admission, his condition was provisionally diagnosed as carotid artery narrowing, posing a threat of stroke. An angiogram was proposed in order to confirm or refute the diagnosis. The general nature and purpose of the procedure was explained to the plaintiff, and certain of the attendant risks were identified. The plaintiff was advised that there could be problems ranging from virtually nothing at all to death. The plaintiff was told there was also a possibility of loss of limb. No other risks were disclosed. Although the defendant surgeon was aware of the risk of stroke attendant upon the angiogram procedure, he did not refer to it, his explanation for the omission being that a stroke was of less consequence and incidence than death, and hence the risk of stroke would be included in the range of risks disclosed. In fact, the plaintiff suffered a stroke and became a quadriplegic confined to a wheelchair. Mr. Justice Krever, after carefully considering the material risks formula propounded in Hopp and Ribel, was persuaded that the duty of disclosure had been breached, while observing that the information conveyed by the defendant to the plaintiff may have met the medical standards in 1973, which was the year the plaintiff underwent the angiogram. He concluded that it failed to meet the legal standard because, and I quote, "Although the risk of death was mentioned, the risk of stroke was not, and it is not an acceptable explanation to me to say that mentioning death, the more serious risk, comprehended stroke, a less serious risk. It is not beyond the realm of possibility that a reasonable patient may be prepared to run the risk of death, but not the risk of stroke. In any event, this was a matter for the plaintiff to weigh." However, having made out a case for negligent disclosure, the plaintiff was unable to demonstrate the requisite causal connection objectively determined. Mr. Justice Krever reluctantly concluded that the plaintiff, given his symptoms, various episodes of blindness, and the risks they posed, possible stroke, assuming the plaintiff was suffering as diagnosed from a carotid artery narrowing, would not have declined the procedure even if properly apprised of the attendant risks. In non-life-threatening situations, where the incidence of the risk attendant upon the treatment is negligible, trial courts have at times adopted a modified approach to reach the same result. In Considine and Camp Hill Hospital, a case in the Nova Scotia Supreme Court, the male plaintiff, aged 52 and happily married, underwent prostate surgery, known as a TURP, to correct an obstruction of the urinary tract. While such procedures were usually successful, there is a statistical risk of between 1 and 4% of resultant urinary incontinence. During the course of the surgery, the wall of the prostatic capsule was perforated. Even after further surgery, the plaintiff suffered from urinary incontinence and impotence. At no time had the plaintiff been advised of either of these risks. In that case, the court chose to defer consideration of the issues of materiality of the risks. The risk of impotence was rated at almost 0 in the plaintiff's case because the prostate was not going to be removed, and the requisite scope of disclosure until after it had determined that the reasonable patient would have consented to the surgery in any event. Only after deciding against liability did the court admonish the defendant doctors and suggest a possible breach of the requisite standard of disclosure. Even those courts which have dealt with the scope of disclosure head-on have demonstrated a discomfort with the Hopp-Ribel material risks formula and have offered little to guide us in the manner of its application. In the case of Vedetto and Kennedy, the first case in which the Ontario Court of Appeal considered the issue post-Hopp and Ribel, the defendant doctor, a gynecologist and obstetrician, performed a laparoscopic sterilization of the plaintiff. The plaintiff, a female Catholic, had sought the surgery despite knowing that her parents, from whom she had kept her plans secret, would oppose the surgery, and despite the fact that there was no urgent need for it. The plaintiff selected this mode of sterilization, referred to colloquially as a bikini cut, because she understood that it involved minimal post-operative scarring. During the course of the operation, her bowel was perforated, resulting in peritonitis and necessitating a major operation known as a laparotomy, which inevitably left an extensive scar. 3 weeks later, a further operation was undertaken to remove a bowel obstruction. The risk of bowel perforation and resulting peritonitis in the course of the laparoscopic sterilization was identified by expert evidence and accepted by the trial judge as 2 or 3 in every 1,000. Although the trial judge had reasoned that the disclosure was inadequate on the theory that bowel perforation was a material risk which should have been disclosed, the argument on appeal was apparently restricted to the defendant's obligation to disclose the risk of a larger scar resulting from the laparotomy. On that footing, our Court of Appeal was prepared to conclude that, quote, the possibility of a larger scar resulting from the laparotomy was not to be treated as a material risk in the circumstances, end quote. Interestingly, the Court of Queen's Bench in Alberta, dealing directly with the risk of bowel perforation following laparoscopic sterilization and citing the Ontario Court of Appeal case in Vedetto, subsequently held that the risk of bowel perforation is not, quote, so unusual, material, or special that failure to disclose it should lead to liability being imposed on the surgeon. The mere fact that the risk is serious does not of itself make the risk material, particularly where that risk is, and this is the key, remote, end quote. If Hopp and Ribel indeed establish the principle that a merely possible consequence which is grave can nevertheless be material, it may be difficult for some to appreciate why urinary incontinence and impotence following upon prostate surgery, possible permanent disability and wheelchair confinement following upon drug therapy for an ulcerative colitis in another case, and major abdominal scarring following upon sterilization surgery were not in the circumstances considered to be material risks requiring disclosure. In any event, it's arguably inappropriate to found a decision on the issue of causation without first addressing the question of materiality, particularly so where the court is not dealing with a life-threatening situation. The post-Hopp and Ribel cases which have imposed liability for failure to inform of attendant risks are few and far between. One case in the British Columbia Supreme Court, Rawlings and Lindsay, held that an oral surgeon had breached a duty of disclosure. In that case, the breach occurred in a situation of elective surgery. The female plaintiff had sought treatment to correct severe discomfort on both sides of her jaw. Occlusal correction substantially reduced the pain, but didn't eliminate it. Her family dentist felt that further improvement might be effected by removal of impacted lower wisdom teeth and referred her to the defendant oral surgeon for that purpose. In the course of the oral surgery, the plaintiff sustained damage to certain facial nerves. In the result, parts of her face became painful, others hypersensitive, and her lower lip and chin devoid of any sensation. Remedial surgery proved only partially successful. Simple tasks such as eating, washing, applying makeup remained extremely awkward. Unlike the majority of post-Hopp and Ribel cases, the defendant oral surgeon had warned the plaintiff of certain of the attendant risks, specifically the risk of nerve damage and resultant numbness. However, he had failed to inform her that such conditions could be permanent. The plaintiff's x-rays indicated roots extending into the area of a canal which contained nerves feeding the face. The defendant was aware, and expert testimony confirmed, that between 5 and 10% of patients showing roots extending into this canal suffer nerve involvement. He also knew that while in the majority of cases the resulting paresthesia and hyperesthesia resolve themselves, in a few cases impaired sensation to the lower lip and jaw may be permanent. In concluding that the defendant had failed to adequately disclose the relevant risks, the court was of the view that the defendant's warning about possible numbness secondary to nerve involvement was insufficient. In this case, the court stated, he should have dealt specifically with the duration or symptoms associated with such damage, including the possibility, admittedly remote, that the damage might be permanent. Without such a discussion, the ordinary patient would not be alerted to the true and serious nature of the risk. He should also, in my opinion, have discussed not only the possibility of numbness, but the quite different possibility of pain and discomfort associated with paresthesia and hyperesthesia. These cases give a factual footing upon which the courts are now struggling with the question of informed consent. I'd like to come back to that after I deal with the second question, which is the matter of novus actus, because often the issues are arising in cases involving informed consent, often not, and it's a question that has to be now addressed. I'd like to put the following fact illustration to you and deal with it in that context. Let's presume that we have a plaintiff who has suffered injuries by reason, for example, of the defendant's negligent operation of a motor vehicle. Plaintiff's injuries are exacerbated by treatment subsequently provided by a doctor, or such treatment causes harm different from that originally sustained. If the plaintiff has sued only the original tortfeasor and has not chosen to join as a defendant those who treated him, is the original tortfeasor liable for all of the plaintiff's damages, including those caused by the healthcare professional? Does the later negligence in medical treatment constitute a novus actus interveniens sufficient to break the chain of causation and end the defendant's liability for events and damages occurring thereafter? The concept of novus actus, or a break in the chain of causation putting an end to the defendant's liability for damages, which historically has been examined under the heading of remoteness of damage, developed at a time when the test determinative of recoverable damages was the existence of a direct causal connection between the injury or the damage and the negligent act. In other words, so long as the consequence was direct, it was irrelevant whether it was foreseeable. The test changed with the House of Lords decision in the Wagon Mound, in which it was held that although the plaintiff must in every case establish that the damages complained of were caused by the negligent act, only those damages which are reasonably foreseeable are recoverable. Although courts continued to speak of a break in the chain of causation, the new explanation for the legal result of such an event was that the effects of the defendant's original negligence had been halted, so to speak, by the intervening act of another, which the defendant could not reasonably have foreseen. Long before the Wagon Mound, it was settled law that a tortfeasor who through his negligence caused injury to a person and placed the latter in the position of seeking medical, dental, or hospital treatment assumed the inherent risks, complications, bona fide medical error, or misadventure flowing from them. Any increased damages occasioned by the non-culpable or non-negligent intervention of a healthcare professional were the responsibility of the original tortfeasor, provided reasonable care had been used in the first instance to employ a competent practitioner. That principle remained unchanged after the Wagon Mound on the basis that it was reasonably foreseeable to the original tortfeasor not only that a person negligently injured might require medical assistance, but also that there could be non-negligent error in the provision of such services aggravating the injuries or causing new ones. What of intervening negligence or other culpable conduct on the part of the healthcare professional in treating the victim of a negligently caused accident? Is the original tortfeasor liable for the results of their later actionable wrongs as well? Although, strictly speaking, obiter, the Ontario Court of Appeal in the case of Mercer and Gray, which predated the Wagon Mound, suggested that he would not be, and I quote, "There may be cases where the medical or surgical treatment is so negligent as to be actionable. This would be, in effect, novus actus interveniens, and the plaintiff would have his remedy against the physician or surgeon, but that the defendant would have to prove in the proper form," end quote. That same approach was subsequently taken by the House of Lords in the case of Hogan and Bentinck West Hartley collieries. Both in Ontario and England then, prior to the Wagon Mound, negligence in the treatment rendered by a healthcare professional to a victim of a negligent occurrence was considered per se sufficient to constitute a novus actus interveniens and relieve the original tortfeasor from liability for injuries that flowed from the treatment. In theoretical terms, the damages additionally sustained as a result of the medical negligence were not directly caused, as they resulted from a break in the chain of causation and were thus too remote. Since the decision in the Wagon Mound, the legal effect of medical treatment that exacerbated the plaintiff's injuries has been considered most frequently in the context of non-negligent medical error. It has been argued that non-negligent medical error, be it a failure to treat, unnecessary treatment, or poor treatment, is not reasonably foreseeable vis-a-vis the original tortfeasor. These arguments have been uniformly rejected by Canadian courts at both the trial and appellate levels. Madam Justice Wilson, as she then was in the Ontario Court of Appeal, stated in DeWin and Caprillion, by way of comment on such an argument, and I quote, "I have concluded that it is preferable to treat medical error as a fact of life and therefore reasonably foreseeable within the principle of the Wagon Mound. Mr. Justice Aikens of the British Columbia Supreme Court has expressed this view in Watson and Grant, wherein he states, "It is reasonably foreseeable that an injured person who seeks medical help may, not will, suffer further loss or damage because of error in medical treatment." End quote. It's to be noted, however, that in the DeWin case, and indeed in all cases dealing with non-negligent medical error, the courts specifically stepped away from overturning the principle pronounced in Mercer and Gray. When considering negligence in treating injuries which were themselves negligently inflicted, our courts have continued to recognize in the abstract that even applying the test of reasonable foreseeability, a defensive novus actus can still be made out, the burden to do so being on the defendant, and in most instances, the defendant has failed to discharge that onus. In none of those cases, however, has there been an in-depth analysis of the relationship between reasonable foreseeability and novus actus in this context. Only a few Ontario cases have dealt squarely with the issue since the wagon mount. One is the decision of Mr. Justice Parker in the case of David and Toronto Transit Commission. That action arose out of a motor vehicle accident. Plaintiff sued two drivers who in turn added as a third party the surgeon who had treated the plaintiff for his injuries. The court found that the plaintiff's injuries were aggravated by the negligence of the surgeon who had fused the wrong cervical vertebrae. On the basis of Mercer and Gray, the defendant drivers were held not liable for damages flowing from the actionable negligence of the surgeon. In reaching that result, the court rejected the reasoning in an earlier case of Mr. Justice Haynes, the case of Colasar and Jeffries. Unfortunately, the court in the David case did not expressly analyze its findings or the principle of Mercer and Gray in the context of reasonable foreseeability. The question of whether or not negligent medical treatment will continue to constitute a novus actus in these circumstances has been raised on several occasions recently. The continued applicability of the principle in Mercer and Gray was accepted by Mr. Justice Griffiths in the case of Katzman and Yake, another case arising out of a motor vehicle accident where the defendant driver joined as a third party, in this case the oral surgeon who had treated the plaintiff, alleging that her injuries were for the most part caused by the dental treatment he provided and not by the accident. On the application of the third party, Mr. Justice Griffiths struck out the third party notice. On appeal from that order, the Ontario Court of Appeal noted that there was no decision binding on it to the effect that subsequent medical treatment that is negligent per se constitutes a novus actus interveniens. The court went on to express the view that the law in this area is unclear and, given the importance and frequency of the type of occurrence, declined to express its opinion in interlocutory proceedings, leaving the matter for the trial judge. Now, one of the corollary questions that arises when one considers this question is the application then of the Negligence Act on the question of novus actus. And there is some debate, or appears still to be some debate in the cases, as to whether, under the Negligence Act, contribution is limited to joint tortfeasors or includes, as I would expect it does, and as certain cases indicate it does, concurrent several tortfeasors. If that is the preferable approach, and it applies to concurrent several tortfeasors, then the case of Katzman and Yake further addressed the question in that context. It nevertheless remains critical to establish a requisite element of concurrence among tortfeasors, even if the tort is a several concurrent tort. A commonality in causation and damages must be present. This appears to have been the point that was seized upon by Mr. Justice Griffiths in the Katzman and Yake case when he set aside the third party notice. It's clear that the question of informed consent is a matter with which the courts are currently struggling. And as was suggested recently by Mr. Justice Krever in the case to which I made reference earlier, it may be that the answer lies not in the judicial process in terms of attempting to establish fault, but rather on a concept of no fault or no liability and recovery without the need to establish liability on the part of the practitioner. I think it important that the question of novus actus be resolved and resolved quickly for the benefit of litigants, particularly now, when often, as is often the case, in motor vehicle occurrences or other type of torts, the process is being employed so as to join the healthcare provider as a third party to that process. If, in fact, negligence per se will operate as a novus actus so as to preclude the liability on the part of the healthcare provider, then some guidance from our Court of Appeal, or indeed from the Supreme Court of Canada, would be welcome on that topic and provide certainty for the benefit of the healthcare professional who, at this point in time, is somewhat uncertain as to what his exposure is. Thank you very much.